Thank you for joining us. I'm Robert Theobald, Small Business Ombudsman and Vice President of Small Business Services here at the Arizona Commerce Authority. I'd like to welcome you today to our Small Business Boot Camp. As we like to do, if you're new, we'd like to start by having everybody post up in the chat where you are tuning in from. We'd like to see where throughout the state and sometimes other states we have people joining us. So we've got Oro Valley, Tucson, Gilbert, Tucson, Bisbee, Peoria, Mesa, Chandler, Glendale, Phoenix, Scottsdale, Mesa, Phoenix, South Phoenix, Carefree, Peoria. All right. Anybody else want to join in and share where they're tuning in from? Again, we like to see, sometimes we have people from outside the state, all over the state. So we really enjoy seeing where our participants come from. Lake Powell, all right. Tempe, Yucca Valley. Excellent. Well, thank you for sharing that with us. As we get started, we'd like to first recognize all of our community partners. We could not do these webinars without them, without their time, their effort, and their expertise. They're also willing to give back of that time and expertise to help small businesses throughout the state. Also, for those that are new, the Small Business Boot Camp is designed to help small businesses prepare, plan, and grow. And we do that through the Tuesday morning webinars like today's. And then we also do hands-on workshops, virtual workshops, and other programs to support small businesses throughout the state. So we're glad that you registered. You'll get on our email list, and we'll send out just a one weekly email with updates and with our upcoming sessions and workshops and webinars and lunch and learns and special sessions and whatever we may be doing to help bring this information, bring quality information to small business owners. One of the great resources that's part of the Small Business Boot Camp is our Small Business Content Library. We take advantage of the tools within Zoom, and we record every virtual session, and we house those in our content library so you can access the recordings and the slide decks from our presenters at any time you want there in the content library. It is an amazing resource, and you can find well over 300 recorded webinars and presentations that you can review. Also, the ACA has a number of other programs that help support small businesses. I'm not going to read through these, but you can see that. You can find them all, plus more at azcommerce.com/programs. However, one of the programs we do like to talk about is our small business checklist. You scan that QR code, it'll take you right to it. But Faith will also post a link for it in the chat. But the small business checklist is an online interactive resource that helps entrepreneurs that are looking to start a business and or expand their business in new areas to understand the commonly requested licensing and registration and compliance requirements at the local, state, and federal levels. You can find a ton of great information in there. The web-based checklist is very in-depth, but we also have a shorter, quicker response with Sally, our state and local licensing information virtual assistant. So give Sally a try and see if you can get the answers you're looking for, and share your feedback on Sally. We're always trying to make her more effective and more efficient. So give that the test if you get a chance. So with that, we want to share a few small business updates. Coming up on August 14th, this is a small business workshop. It is in person only. It is in partnership with the Phoenix Business Journal, Wells Fargo, Blue Cross Blue Shield of Arizona are also part of it. We're going to be focusing on generative AI and 3 ways to use these free tools in your business. So we're going to have some experts in for that. So hopefully you can make it with us. We'll post the registration link there is a small cost to participate in that one. And then we also wanted to share some information that score.org that has shared. They have their 60th anniversary pitch competition. And so it's open to small businesses throughout the country. There's a virtual competition for Arizona businesses. And so you can win up to $20,000 in that program. So take a look at that. SCORE is a great partner. They've been on with us many times for many boot camp presentations. And they are a national program supported by the Small Business Administration. Another great program that we have currently preparing to start is the Small Business Digital Academy. The applications actually closed this Friday. So if it's something you're interested in, it is a multi-week course that teaches entrepreneurs and small business owners how to utilize their website, social media, e-commerce, SEO, and analytic tools to promote their business digitally. It's kind of a digital one-on-one for small business to help you get that base to grow and strengthen your business. So that is a virtual program. It's a 3-week cohort style program, no cost to attend, but we encourage everybody that applies, and if they're accepted in, to attend all 3 sessions to get the most out of it. So take a look at that. Again, we have the link posted in the chat for it. And then our upcoming sessions, we've got a great lineup coming up over the next 3 weeks, and we actually have the rest of the year mapped out, and it's an exciting rest of the year with our boot camps. But next week we have Empowering Cybersecurity Excellence, and it's a topic that a lot of people like to ignore, but after last week's computer issues that many people faced, including some very large businesses, cybersecurity is an important topic. And then we have leadership and project management session. And then we have a great video session from our good friend at Financial Potion, Taylor Wellman. She'll be back with us talking about using video to unlock success in your business. So great lineup. We hope you can join us for those. But everybody's here for today's session, so let's jump right in. We've got a new speaker with us. We're really excited to have Paloma Goggins with us. She's the owner of Nocturnal Legal. It's a boutique business law firm in Scottsdale. So we're really excited about this session. It's not what we've done yet, so it's going to add to the content library quite well. And so, Paloma, I'm going to stop sharing my screen and turn it over to you. While Paloma's getting set up, we'd like to remind everybody, if you look at the bottom of your screen, you're going to see some links you can use. One is the chat, another is the Q&A, and we like to have everybody place their questions in the Q&A. So they don't get lost within the chat. So that way we can use the chat for some other interaction that we may have. That's just a little housekeeping piece. But Paloma, it is all yours.
Thank you. Good morning, everyone. I'm excited to take you through this journey. I will, at first here, let me see if I can get there we go. Talk about the agenda first. So the slides are intended to be somewhat comprehensive no matter where you are in your journey. So I will start with the organizational documents. So if you already have a pre-existing business, that might be a little bit basic, but it's for those that are just starting out and not realizing, and perhaps someone who's even farther along, realizing that organizational documents need to be updated. So it might apply to everyone, but some of the stuff at the beginning might be more rudimentary. And then we'll transition into kind of the key other documents that are related to operating a business, employment documents, commercial agreements, and things that relate to protecting IP. A little bit about me. I attended the University of Wisconsin-Madison for my undergraduate degree. I'm actually from Wisconsin originally. I went to Washington University School of Law for my JD. I am an avid hiker. I love the outdoors, big on doing anything related to travel and photography. So always welcome to suggestions on hikes in parts of the state that are less explored. I love things off the beaten path. I won't waste too much time on my intro slide because I have a lot to cover. So apologies in advance. I'm going to talk somewhat fast, but I want you to get as much benefit from this slide show as much as possible. So starting with our organizational documents, there are three main types of entities. So most commonly, a lot of people will start their business with an LLC, but you also see people with a lot of corporations. Partnership is arguably the least common in terms of form of entity. That does not apply, and I'll cover this in a later slide, does not apply to those that are taxed as a partnership. So for an LLC, it's really great for single member operators. It's better than being a sole proprietor. There's better protection if you're operating a business as a sole proprietor or through your individual name. I always recommend to my clients or anyone starting a business to form an LLC because of those protections. And what's nice is that as the business grows, the LLC can grow with you. So you might have, just to start yourself, but that as you add partners or add investors, it can morph and change. We'll get into that in the next slides. Corporations are more common when an entity is looking for private investments in the future. A lot of private equity company investments like corporations, but there are annual requirements. So if you form an LLC in Arizona, you're probably familiar that you don't have an annual filing requirement. That's not true if you're in other states, but for corporations, you do have annual filing requirements every year. And then it is a more formal structure for governance. So you will have more P's and Q's around how things operate within the corporation that maybe you could draft around in an LLC. And I'll get into that in the next slide. And then finally, partnerships, like I said, the least popular choice just because there's so much flexibility in an LLC. There are two types. One's a general partnership and one's a limited partnership. The main differentiation between the two is one ends in an LLP and the other in a GP. So breaking it down, for an LLC, you have your articles of organization, which when you form an entity through the Arizona Corporation Commission, the ACC actually will spit out a general version of articles of organization, but there's also the option for people to draft their own. Some people don't realize that you can actually draft additional rights and obligations into your articles of organization. It's not exactly common, but it can be a way to essentially add things to the articles that weren't in the operating agreement and perhaps gives a manager additional rights or responsibilities. An LLC can be member managed or manager managed, and the main document that is used to kind of cover the daily operations is the operating agreement. And so the operating agreement is essentially can be exceptionally, what would I consider it, simple or very complicated, depending on the number of members in the LLC. And I'll get into some of this in more detail. This is kind of my broad overview slide. Additionally, you have oftentimes a buy-sell agreement that can be separate or it can be incorporated into the operating agreement. The corporation side, you have articles of incorporation, and then you have two documents that mirror the operating agreement and buy-sell for the LLC, which is the bylaws and the shareholder agreement. A lot of people don't realize that the bylaws are not enough when you have multiple shareholders, so you should always consider if you have multiple shareholders to have a shareholder agreement. On the partnership side, it's pretty simple. You have a partnership agreement. Want to note here that tax elections are not the same as legal entity changes. So a lot of my clients will ask me, well, I'm an S corporation, and they'll say I'm a corporation, and I'm like, yes and no. So you can be a corporation that elects S corporation status, but you can also be an LLC that elects S corporation status. So the underlying legal formation of your entity does not change based on your tax election. I just want to put that out there because that's a pretty common misconception. So, sorry, I was getting ahead of myself on my last slide. So first and foremost, articles of organization or incorporation. Like I said, they're automatically generated by the ACC. You can draft them. You can also amend them later through the ACC or on your own and upload your own form. That sometimes is easier if you're adding specific rights. The key elements in the articles of organization or incorporation is relevant to what the interest holders are. So it's usually going to list the members or the shareholders. It will list who's the manager or board of managers if it's a manager managed LLC. Say that 3 times fast. it will include the principal address and then also who is the registered agent for the company. And then, so a couple of notes. You want to keep your articles of organization or incorporation updated. I do a lot of work in the M&A space, helping people buy or sell businesses. And oftentimes when we get into the thick of it, we realize that either the articles of organization or incorporation haven't been updated for years, or they improperly show the wrong individuals because maybe someone was bought out. And so I always encourage people to keep the articles updated on the Arizona Corporation Commission, because it's honestly one of the few things we can do to confirm ownership. And then articles are very important for banking. Anybody who has started a business and wants to go open a bank account knows that you have to have your articles with you. Moving on to the operating agreement. So as I said before, this is what governs the operation of the LLC. So there is this kind of dichotomy between including buy-sell language either in the operating agreement or outside of it. So if you're not familiar, a buy-sell agreement is the document that essentially governs how membership is held and transferred. So it would cover what happens if someone wants to transfer their membership to another member or to a family member or sell it to a third party. It originally can be all in the operating agreement. Some of it is preference. I learned recently that the underlying reason why a lot of times people will pull the buy sell language out of the operating agreement was related to insurance policies. That's really not so much the case anymore. So a lot of times what I personally like to do is include all of the language in one document, because the more documents you have that are all separate, it gets harder and harder to keep them all organized and updated and know where they all are. And I know as soon as you start operating your business, all of the sort of clerical and organizational stuff usually falls by the wayside. So I would say the least amount of documents for your organizational stuff, the better. And then that way, when you are updating an operating agreement sometime in the future, you can update the buy-sell language at the same time. So key elements that the operating agreement includes, it has the ownership structure, the management duties, decision-making processes. So this is more or less like who can vote, what would be considered a vote that passes, what is majority. So sometimes operating agreements can have either majority membership as the voting power, or it can have the votes be a single vote per person. So there's some flexibility in there. And then related to transfer of membership interest, if you're including the buy-sell language, deadlock and the big Ds. So these are the two big ones that I always talk about with my clients when talking about operating agreements. So if you have an even number of members, so let's say you're a single member, you add another member, you now have two, or you start your business with four, having four people all vote unanimously on key topics could result in what's called a deadlock, where two people are pro and two people are against. And so in those instances, you have to have language in your operating agreement that explains what should happen if a deadlock occurs. This usually results in either arbitration or having a third party come in, which can be a non-traditional third party. Perhaps it's the manager that comes in, or perhaps it's just someone that everyone trusts to come in and break that deadlock. And then the big Ds are death, divorce, and disability. And all three of those should be covered and addressed in the operating agreement, and what should happen to each person's membership in the event of happening. Touching quickly on the buy-sell agreement, in case this isn't included in your operating agreement, like I said, this covers how the members can transfer or sell their membership in the LLC. As I said, I prefer to keep this in the operating agreement, but it's not make or break if you already have the documents drafted and it's outside of the operating agreement. Key elements that it can include related, if you have it external, are still the big Ds, triggering events for transfer, tag and drag along rights. That's where members can either, in the tag example, they can decide that if one person is selling, they want to join in on the sale of all of the membership interest. Drag along is where one member can decide to take all of the other members with them in a sale, whether they like it or not. And then typically it'll also cover redemption rights, which is the LLC's option to buy back interest from members, depending on certain instances occurring, sometimes the big Ds. Oops, yes. Where am I? Here I am. Okay. Switching now to corporations. So if you have a corporation, you'll always have bylaws, which is the core operation of the business itself. It does not include shareholder relationship information. That would be included in the shareholder agreement. We'll talk about that in a second. Key elements that it typically includes is the general company information, your board structure, how meetings will occur, how often they occur, who should vote, the voting process, what the powers should the directors have, or if it's a single director. Committees are often put into place when the corporation is more complicated and you need multiple levels of approval for things. And then what should happen for dissolution. Operating agreements always include dissolution as well. I know I didn't probably have that on there, but shareholder agreement is a secondary agreement that is important as soon as you have more than one shareholder. It governs the relationship between shareholders. And it's sort of, if you had to liken it to something in the LLC, it's like the buy-sell language or buy-sell agreement. So it includes the shareholder rights, how they can transfer their shares, whether there's any sort of company rights related to clawing back shares at a later time. There's similar tag and drag rights that we just talked about in the LLC. You should still include some sort of deadlock language if there's voting among shareholders in an even number, and then any sort of restricted activities. So something that's common in both an LLC and corporation is that you might want people to not compete, especially if they have ownership in the company. You don't want them to compete directly with your business, and so that might be a restricted activity. In the legal world, we call that like non-competition or non-solicitation, those types of things. And I know we recently had a change in the law related to non-competition, but that's solely related to employment. So if you are restricting non-competition in a organizational document, it falls outside the scope of that new rule, if you're familiar with it. And then finally, for a partnership agreement, just generally, this covers the partner relationship, just like an operating agreement and just like a shareholder agreement. Just it addresses the unique qualities of partnership liability, since it can be either a general partnership or a limited partnership, which shifts the liability a little bit depending on how you have it structured. And then same things as in the operating agreement or the shareholder agreement. You have the decision-making processes, how transfers of interest can occur, what should happen in a deadlock, and the big Ds. I am checking my time. I'm cruising along. I want to make sure we get through all of this. So employment-related documents, a lot of people, when they start adding employees, whether they're part-time 1099 or they're full-time W-2 employees, a lot of times businesses won't go through the process with independent contractor agreements and formalizing that relationship. So I always recommend 1099 or independent contractors get into an agreement with the business itself. Not only does it cover the basic terms of the job and the expectations, but it will cover things that are related to, and this slide is now outdated, so the non-compete stuff is a little bit wonky. I won't get into that in this presentation, but non-disparagement is a really big one. In case something were to happen where you decide to let that person go, you don't want them talking poorly about your business if the relationship changes. It also can cover how pay is done, what the expectations of the role are, how the relationship can be terminated, protection of your intellectual property, things like work made for hire, which helps protect the deliverables that they provide to you as things that you own, not them. And then essentially the ultimate goal of an independent contractor agreement is to reduce liability in case they're doing something where you might not have more control over how they operate. Inherently, a 1099 is someone that is going to just take direction and complete the work at their own pace, right? So next slide is a little bit more helpful. Employment offer versus agreement. So when we switch for a 1099 to a W-2 or someone who's more full-time or even a part-time W-2, the difference between an offer and an agreement for employment can be pretty staggering. So I always advise that you shouldn't have an agreement, a formal agreement in place when you really should have an offer. An offer is more related to at-will employment. It's not binding. There's no severance. Usually there's 2 weeks notice for either person to terminate the relationship. Both of them will inherently outline the job responsibilities, but if you put together, this is kind of as an example, a lot of clients that come to me, they'll have pre-existing employment agreements with everyone in their business, and they took them, just off the internet and kind of spruced them up. And the hard part about that is not only is the agreement not applicable to their business specifically, but it created this like binding obligation for them. So it can switch the at-will status of an employee to something that's more binding. And even if you remove the severance from it, there's an inability to potentially terminate the relationship as easily as an at-will employee. So I always warn against that pitfall, is that in case you have employment agreements in place and not offers, when you should have offers, which is essentially just like a bulky letter, right? I always advise that if you can get them switched over to an offer, it's much better for you in case in the future things decide to change. Moving on to commercial agreements. So in addition to your employment agreements, something that is really important in this process is to have customer-facing agreements. I can't tell you how many of my clients come to me that are small businesses that don't have anything in place other than an invoice. I know that's super common. Unfortunately, it doesn't cover the scope of services as well as you would want them to. So whether you're a service-based business or a goods-based business, the two main agreements is a service agreement or a purchase and sale agreement. So when selling goods, it's a little bit, you can keep it more streamlined, but you're still going to want to have someone agreeing to terms of service on the back end. So think of like your website. If you're only an e-commerce business and you're online selling goods and someone clicks add to cart and then they check out, the checkout process should still be subject to their agreement to the terms, which the terms would then cover things like the return policy, what happens if the goods never arrive, your shipping, any other kind of P's and Q's that you might have. What happens if it shows up and it's damaged? What are the protocols and policies in place? And so that kind of allows you to say, when someone comes to you with a question or an issue, they can come back to you and offer. You can tell them, look, you agreed to these terms as part of our checkout process, and this is our protocol. This is how you can follow it. Either here's how we'll refund you, or here's how we won't. Right? So it gives you more power to say, here's how we work with our customers across the board. On the flip side, on service agreements, a lot of times people will think, oh, like I'll just give an example of a landscaping company. If somebody comes to the house and they do a quote and they put all the things in and the person signs the invoice or the quote, but they don't have a formal agreement on the back end, what happens if the customer decides they want to change the design? Are there design change fees? What happens if the customer decides they want to terminate the relationship mid-project? A lot of times service-based businesses have, especially in the trades, they have pre-existing purchases related to performing. So what happens with all the rocks you purchased? Does that get paid for by an initial retainer? How does payment get collected? Those types of sort of P's and Q's. Even if you're not a trade service-based company, a good alternative example, and if you have a website, you're familiar with potentially signing one of these agreements, is a company that does websites, right? So you still have all those design change potentiality, but you also have the sort of general terms and conditions of how the relationship works. And so a lot of times without these in place, you have only proposals and invoices. You don't cover dispute resolution. What happens when someone's mad? How do you get out of the relationship? How do you stop working with a bad customer, right? We always talk about, how do we have relationships with customers and clients that benefit our business? And on the flip side, inherently, you're going to run into some customers and clients that you want to terminate just because you don't enjoy working with them, or maybe they're creating additional issues in your business that you didn't anticipate. So it goes both ways, right? And having a document that covers all of that can really help protect you in the event you actually want to terminate that relationship. And then finally, liquidated damages. So in some instances, you might decide, hey, if you want to terminate our relationship early, Here's the fee to terminate our relationship. This is really common in software as a service agreements, but it can be utilized as a way that if you're onboarding a new customer or client and the bulk of your time is sort of repaid over the course of your relationship with that customer or client. So think really labor intensive onboarding at the beginning of the relationship that you essentially recoup as the monthly fees come in. That liquidated damages provision can save you on the backside if someone decides to terminate well before the relationship has hit 1 year and you've recouped all that time from the beginning. Finally, not finally, I have more slides. Vendor agreement. So these are agreements that you have with your service providers. So shift away the idea of someone who you're, the business is making a website. Let's say you're going to someone who's going to make your website. That's a vendor-based service provider. It can also be your software providers. I always tell people every agreement is negotiable. Granted, we're not going to read the terms and conditions for Microsoft Office and go to Microsoft and try and negotiate with them, but there are smaller software-based services that if they give you an agreement, don't think that just because it's on the website or they gave you a PDF for signature right away that you can't negotiate the terms. And I would argue that you should always read the vendor agreements to make sure you aren't agreeing to things like the liquidated damages provision. While it was certainly helpful in your case for you, it's not helpful for you when you sign it in a vendor agreement. A lot of times software as a service will put that in and say, look, you're signing on for 2 years. If you decide to leave us early, you have to pay all of the fees for those 2 years just to get out. So they're getting their money one way or another. I've also seen a lot of companies that sign agreements and decide they want to terminate because the relationship has kind of soured or the deliverables aren't coming in. And because there's language in there that stipulates they really can't terminate, they're really just stuck in the agreement for the rest of the term. So it definitely pays for you to read it or to have your attorney read it for sure. Key provisions that you can negotiate: scope of services, things that might be missed from an initial call or additional add-on services, how payment can be made, termination, like we talked about, and then liability and indemnification obligations. Relevant to what we were talking about at the very beginning is that, related to cybersecurity and breach, one of the things that I like to have clients sort of try and negotiate in a lot of these vendor agreements or relationships with other third-party businesses that are helping supply part of the services for their customers or clients is related to data privacy and data security. So if you're kind of entering into a relationship with someone who's also going to be processing heavy data on your behalf or potentially in your systems, helping perform services for your customers or clients, you want to have the data security part of it addressed. Because inevitably, even if you have someone have all of the protection in place related to a password manager and their own login, anybody who has an access point or is processing data that you originally owned leaves you liable, potentially liable. I don't have to say liable. So something to definitely think about. And obviously each business's situation is unique, and part of deciding whether you need sort of indemnification obligations covered, which is essentially a fancy way of saying, if you do something wrong, I can come back and it comes to me as I'm responsible. I can come back to you and you cover me. So a very simple explanation of how indemnification works that I like to use with my clients is that think of a manufacturer who's making lawnmowers, and they use a blade company that manufactures the blade, and they put the blade into the lawnmower as part of the manufacturing process. Now, between the lawnmower company and the blade manufacturer would be an agreement about related to the purchase and sale of parts that they created. Part of that agreement would include indemnification that stipulates that if the blade comes off due to faulty installation of the lawnmower company, and someone sues the blade manufacturer could then go after the lawnmower company to say, hey, not our fault because we didn't install it. So hopefully that kind of, it's a more tangible option, but I think using indemnification and service-based agreement examples can sometimes be hard to wrap your mind around. Next, the lease agreement. So a lot of people end up getting space in the valley or anywhere around the state. And I will tell you, the lease agreements I see in the Phoenix area are a lot more aggressive than in some other areas of the state. And so it's always worthwhile to review the agreement with an attorney, because there are key portions of the lease agreement that inherently the landlord isn't going to allow you to change, but there are other parts that you can always push for. And I always say, look, let's push for everything that's important to you, that protects you more, and let's see what we can get added in, right? Because at the end of the day, if we get a lease back that we've revised and nothing gets admitted, is there a question now of how easy it's going to be to work with the landlord, and do we still want to rent the space? And on the flip side, we've also done things where we've revised a whole lease agreement, and the lease agreement comes back and a lot of it is included, if not all of it. So there's really a positive effort in trying to get things added to the lease agreement, even if it seems like a very large undertaking. Some of the key provisions to review: renewal rates, option to renew at all. So sometimes people don't have the option once the lease terminates, how long the lease is for, what happens if the premise is damaged by fire or casualty. This is always related to rent abatement. Some leases don't have the option to have rent abatement unless the landlord deems the space untenantable, which is really just a fancy way of saying you can't live and work in there, right? And then important tenant rights. When are you going to get the deposit back once the lease terminates? What obligations do you have to keep the space in good working condition? Is it a triple net lease where you're on the hook for not only your the insurance of the building, the additional rent for the community property spaces, and taxes? So it becomes potentially pretty cumbersome. So definitely worth reviewing and potentially negotiating 100%. All right, I am rounding the corner. I want to make sure I have a little bit of time at the end, and so I'm going to talk a little bit fast as we go through these IP related agreements. You're entering into an employment arrangement with an offer letter, or whether you're entering into a relationship with a third party, you should always, if you're disclosing important intellectual property, you should always have a non-disclosure agreement ready and at hand for them to sign. So this covers all of your confidential information and restricts the person who has received it from sharing with third parties or allowing it to be disclosed unless legally required. It also covers things typically when it's related to an offer of employment, such as non-circumvention or non-solicitation, which non-solicitation is a way to prevent them from poaching employees if they leave. And then non-circumvention is a way to prevent them from essentially getting into a working relationship with a potential customer or client, cutting you out from the process altogether because you originally introduced them. Finally, it does cover responsibilities when the purpose is complete or the NDA terminates. So let's say the person signs an NDA, it lasts for 3 years beyond someone's employment, or perhaps it just lasts for 3 years period if it's with a third party. At the end of that relationship, you can say, hey, I want you to delete everything that you have on your computer, and then tell me or certify that you've deleted it, or return. You can return things too. And they can be both one way or two way. Two way is really only necessary if you're going to be on the receiving end as well. Finally, licensing agreement. So this addresses the use of your IP by a third party. So licensing agreement can be pretty important if you're going to be taking something that you own and allowing someone to incorporate it. Sometimes, depending on the scope of the license, it can also be based on a pay per use. So essentially anything that you can think of that might be incorporated or utilized by a third party can be covered by a licensing agreement to restrict how they use it, how ownership that you have is retained, and then how that relationship might come to an end if you find out that the IP is being utilized in an inappropriate manner or being resold or in some capacity. So this may be included in a customer agreement or an independent contractor agreement. think of, I'll just give a kind of a simple example here. So if you are providing customers with detailed reports about their business or about some sort of, I'm trying to think of a general example here, something about their business that you're doing from a service perspective, and you provide this really nice report, and the report includes this proprietary chart and data that you use as part of like an algorithm or a program. And so you want to essentially say, hey, this report is yours because you paid me to provide the report, but it includes proprietary processes and essentially output that we want to retain ownership of. And so that's how you end up taking the licensing language and putting it potentially in a customer agreement, excuse me, because at the end of the day, you can still say, hey, you get to own this report, but we have pieces of our intellectual property included in the report. So please don't resell the report or the process that we use. Please don't utilize this publicly, don't publish it. You know, some of that restriction on use so that in some way your intellectual property is protected. This is more relevant to someone who might be, you know, in a franchise arrangement, or they're trying to have other people utilize their IP in a way that is respectful. So maybe putting their logo on their products as an endorsement. You might want to have a full-blown licensing agreement that stipulates you can only use our logo for so long as we have the underlying affiliate relationship. And then as soon as that ends, so does your use of our logo. Hopefully that gives some good examples. And we are rounding the corner. I want to leave time for questions because I feel like everybody always has questions, and I know there are some in the Q&A. Let me get to the Q&A.
Yeah, we have some good questions in the Q&A.
Perfect. Okay, I got it now. Okay. So first question, do you need an operating agreement for an individually managed LLC? I assume you mean just a single member LLC, and the answer is yes. So there is an operating agreement that can be put together that is exceptionally simple. It's usually only, I think the one that I typically draft is around 3-4 pages. What it does is it protects your business in the event of disability or death. So a good example, I worked with a family where the dad had a business. It was a construction business. He passed away suddenly and unexpectedly, and he didn't have an operating agreement in place, and he was the sole member. And so the family ended up having to go through probate in order for them to sell off pieces of the company and wind down the business. So in order to prevent that, a single member operating agreement allows you to name someone who can then be admitted automatically, either as a member or a manager, depending on the structure of your LLC, to come in and make changes, continue operating potentially, or sell the business to a third party, essentially giving them all of the power and responsibility. I will say having someone get added as a member might make more sense if the person who's being added is someone who can actually take over and continue operations and wants to do that. Whereas if it's just going to be like a family member or a friend who's going to come in and help wind down the business because you're no longer available or capable, then often making the LLC manager manage and have that person come in as a manager would make more sense so that they don't have ownership of the company. They're just coming in to wind it down. Hopefully that helps. Okay, next question. Grab a little bit of water. Hold on. I know I've been like rapid fire. I just want to make sure we cover everything. Customer agreements for purchase and sale of digital products. Different. Are there examples or templates? So I will say this. Every business is unique, and I advise all business owners to not take things off the internet and try and utilize them for their own purposes. You can certainly take something off the internet and start with it and make some revisions, but I always advise that someone go to an attorney and have them spruce it up, make the right revisions, because inherently anything you pull off of the internet is not going to be the right thing for you. And it might also have the wrong, let me put it this way, each state is specific laws, right? So it might not apply to Arizona in the correct manner. And so in terms of having a document that allows for the sale of digital products, it kind of goes back to that e-commerce example where you have potentially a terms and conditions, and then you would have what's called a click wrap agreement. So a click wrap agreement allows at the end of the purchase process for them to click to agree to the terms of service. And then the terms of service would include all of your sort of terms and conditions in terms of how they handle the digital product. And digital products can have real IP issues, right, related to that licensing topic we just talked about. So terms and conditions related to digital products should certainly cover IP as well, even in the terms and conditions. Hopefully that helps. Next question. My partner and I have a remote staffing agency and work from our homes. We aren't too clear what to do as far as an address goes for all of our legal documents. We don't want anyone to just show up at our front door. Agreed. Set up a virtual office address, but we would never work from there. Which address should go on legal documents? So definitely your virtual address. I don't know if it's just like a mailbox, but one thing to consider is having a virtual mail address that has an actual staff at the building. There are options in Arizona for that. And what it allows is that if you ever do need to have service of process, it can still happen. Technically, your office should have the ability to have your registered agent receive service of process, which is why you have a registered agent. If you have just a mailbox and you want to not upgrade to something that's more, what you can do is you can have a corporate registered agent in the state receive service of process and then have your principal address be your mailbox. But keep in mind from a like digital marketing standpoint, if you have a UPS store where it has a mailbox for you, oftentimes Google Maps will pull the pictures of UPS up. So something to consider in terms of whether you want the UPS store to show up when someone Googles your business. But definitely don't have your home address for the safety of everyone, especially nowadays. I always advise not to have home addresses on business documents. Okay. Cash, your question is, how does this apply to food trucks? I'm not sure which part you want me to apply to food trucks. I'm going to move down to the next question. If you want to ask more specifically, I'm happy to answer. What IP protection would you recommend for third-party vendors registering their property on your brokering service? Thinking of a college course offerings being collected onto a student course search service. So in terms of IP, if you're taking your IP, I'm just rereading the question. I want to make sure I'm answering. So assuming I'm reading this correctly, that you're essentially potentially taking course offerings and putting them onto a third-party platform, or allowing people as a third party to put their course offerings onto your platform, either one, I think the answer is kind of similar, which is that IP protection can flow both ways, right? So if you are operating as the sort of platform for collection of other people's IP, then you would want to have language that addresses whether they retain that IP or if they upload it, you have the perpetual right to play it or resell it or whatever it may be. And then vice versa, if you're the one uploading the material to a third party supplier or vendor, you want to make sure that you can retain your IP and that the license to utilize it is only for so long as the relationship is solid, or maybe you have the option to delete it and they can't replay it without it being uploaded with your consent. So there's definitely ways to have IP protected in both situations, depending on how it's structured. Cash, I didn't get your response, so I'm sorry I can't answer your food truck question. Oh, there we go. Currently built trucks, and I'm launching a new brand in 2 weeks. I want to bring in multiple 5% partners. Got it. Okay. So any business that is going to bring in partners, especially at small percentages, I certainly recommend updating and making sure, even if you don't, let me put it this way, updating if you have a current organizational document, let's assume you have an LLC. If you have a current operating agreement, you're going to want to update that 100%. If you don't have one, you definitely want one. I always tell people multiple member LLCs should never be operating without an operating agreement because it's all hunky-dory until someone gets upset. And then if you don't have one, the Arizona statute falls into place. So it's not the best default for all the members. It's not always in the best interest of everyone is to follow the Arizona statute. So having an operating agreement allows you to override those provisions, which is really nice. As you add ownership to your LLC, you'll have to do some, first and foremost, if you're a sole owner, you'll have to transfer membership. So there's documentation related to that. And then you'll also have to update the Arizona Corporation Commission. And then you'll want to make sure that they join your operating agreement, or if you're getting one drafted in the first place, you'll want them to sign it as well. And then what that does is you have the documentation that shows that you've transferred a percentage, assuming you have 100%, a percentage to that person, which is usually an assignment and assumption agreement. And then you'll have the back end, which is that they're subject to all of the P's and Q's in your operating agreement, which includes their transfer or sale of the percentage. Anybody who has small percentages, and I see this quite frequently in businesses where maybe you're taking small investments in exchange for a percentage, we would classify that as a capital contribution, potentially, as opposed to investment. That can change the nature and status of how that's completed. Or you can also have that small percentage have what we call cliff vesting, or waterfall vesting, or whatever there's like different terms for it. But essentially what it does is it says, we're going to give you this tiny percentage in exchange for your sweat equity over X number of years. So we see that quite frequently with people who have employees that they bring on, and perhaps they're not paying them the full amount that they would like to because they're a startup. They can give them an equity percentage in the business, which is earned as years of experience continue to toll. So the longer you're with the company, the more ownership you retain. So there's lots of ways to structure ownership changes, especially as a business is scaling and growing. And it really just depends on sort of the scope and desire of how you want the business to look 5-10 years down the road. So more of a strategy call.
Hey, Paloma, one thing I noticed in Cash's question is he wanted to franchise rapidly. And so, from my experience too, is if you're looking at doing a franchise model down the road, franchising can get very complicated quickly. So you'll definitely want to be working with an attorney, and probably someone with experience in franchising, because every state has their own legal requirements for franchises. So it may have just been a semantics thing in the question, but I just wanted to throw that out there, so you're aware, Cash, that if you're, or anybody else that may be looking at franchising in the future, that's a piece that can get complicated quick. It can be a great avenue, but you just got to know all the legal expectations that come with it.
Do we have time? Yes, we have.
Yeah, we got time for one more, I think.
I am sole owner of a government contracting LLC, primarily supplies, commodities, short-term services, consulting. Could I contact you for an operating agreement which is most beneficial for federal acquisitions? So yes, I think that's probably a good question to discuss offline, and determine sort of the scope. I know you listed some general areas of which you are involved in terms of government contracting. Government contracting is something I've worked on previously when I used to live in Wisconsin. It can have a lot of red tape, so we should certainly discuss more offline. Sounds good. if I'm happy to stick around and answer any other questions too, but just as a general piece of advice, the things kind of that I covered today, and I know I talked about them pretty rapidly. I think all of the documents that are listed in these slides are really the most critical parts of a business operation. And there are a lot of times when people get into business and they rapidly grow, some of these get left behind. And I'm not saying that you can't have a successful business without some of these documents in place. I just think you're putting yourself at unnecessary risk for potential issues down the road, whether that's unneeded liability that could have been covered off in a customer agreement, or whether that's complicated employment relationships, or simply just disagreements between members or owners of the company. So a lot of this comes to light working with people who decide they're finally ready to exit a successful business, either midlife or end of life when they're ready to retire. And unfortunately, getting all of this in place and sort of quote unquote perfected leading up to the exit or near exit is almost impossible. And sometimes people are unable to exit their business because the shareholder agreement or the operating agreement doesn't allow for drag along rights, or some way to essentially force some of the stubborn other minority members to sell. So certainly something I think it's best to address as you're currently growing or as you're currently successful than later down the road from an end of life perspective in terms of your business.
Great point. And that's a perfect conclusion to wrap up. So thank you, Paloma, for all that great information. You can find her email and phone number there on the bottom of your screen on that slide. The slide deck from today's presentation will be posted with the recording of this session in the content library later today or tomorrow. So you can see the link for that in the chat. But Paloma, thank you again. We appreciate your time and your effort. Great questions from everybody. We want to thank you for sharing those questions that you had. It definitely helps. If you have a question, somebody else probably has it too. So thank you for sharing those. And we appreciate it. We do have, let's see, we got a couple minutes left. We do have a question that just popped in. So are you able to provide an example of a trusted virtual address site or company in Arizona?
So if you type in virtual office address and whatever the nearest city you want to be in, there's plenty of options that will come up. They vary pretty heavily on price. There's a few throughout the valley that are pretty good, but just keep in mind the services they provide can vary pretty drastically. So some virtual addresses are ghost addresses, no different than a UPS box. So you'll want to do a little bit of digging in terms of who can actually be like a front desk staff, if that's what you want, in terms of people showing up accidentally. Sometimes people want to have somebody there physically, even if you aren't, just in case somebody shows up at your address asking for you.
Yeah, there's a number of co-working spaces you might look at and get their base level membership. And you can use that as your address. Your statutory agent might be the one you have listing their addresses as your main, legal address for stuff. So there's a number of different options for that. Excellent. Well, great last minute question. We are right at time. So again, thank you, Paloma. Thank you, everybody, for being with us. We hope that everybody has a great week. And we look forward to seeing you next Tuesday morning. Until then, have a great day. Thanks.
Thanks.